got the question of the approvability test and also what it takes to be deemed a professional out of the way, let's just talk about the general sort of melee of cases that present themselves down at the Immigration Department and how they tend to break down into 3 specific types. And depending on the type that you're in, you'll know exactly how hard you have to work for the approval that you need. So the first is you're an intercompany transferee. You're working for a related employer overseas who's got a genuine need to bring you into Hong Kong. Your Hong Kong entity is deemed to be a suitable and credible sponsor for those immigration purposes. The Immigration Department are not in the business of reinventing pre-existing employment relationships. They don't want to get involved, intermeddle at that level. So 9 times out of 10, intercompany transferee, so long as the applicant is a professional, will get really put through on the nod without too many questions asked at all. Secondly, if you're not an intercompany transferee, you might be a locally recruited foreign national. Now, depending on whether you're a presently resident foreign national or you're presently visitor foreign national, the amount of argument that you need to engage in order to expect approval is markedly different. On the principle that the Immigration Department is satisfied that the employing entity can be deemed a suitable and credible sponsor, and that the skills that are being required in this entity are clearly available to the applicant in those circumstances, then 9 times out of 10 the Immigration Department will kind of accept that, unless you are going from being a sushi chef who's just done a 3-month program at GA and then suddenly wants to write the new Facebook. Arguably not too of a sensational story there. But if it's a sushi chef that has done this course because he's going to reinvent how raw fish is distributed globally on the internet, then why not? But if you're a visitor, then you've really got your work cut out for you. That's the message today. And then occasionally the Immigration Department will see a set of applications where they're seeking to bring in a particular overseas talent who isn't presently working for their international group or otherwise, that they've got a particular role for this person. This person's got a particular skill set that, and the quality of the appointment is such the Immigration Department are not going to second guess these senior executive decisions. So those types of applications, usually no problem at all, but you start getting lower down that sort of ranking of quality of story and scenario, and the more difficult it is to anticipate an approval. So these are the sort of the other bits and pieces that are in play and sweep up behind you once you've gotten the substantive aspect of your application out of the way. The first is that Immigration Department expect to see that there is a suitable and credible sponsor, and that suitable and credible sponsor needs to be able to, in itself, if it's a new company situation, needs to show that it can go on to make a substantial contribution to the economy of Hong Kong in of itself, and you still have to demonstrate that you do possess special skills, knowledge and experience of value too, and not readily available in Hong Kong. And this application falls on the application forms ID 990A and the sponsorship form which corresponds to that, the ID 990B. And it's the employer that serves as your sponsor to this application. So an authorised party from that company, along with the company CHOP, needs to be affixed to the sponsorship form. And as I said just then, if it's a new business situation, the Immigration Department are going to really have a good solid look to see if that entity really is a suitable and credible sponsor for this foreign national visa approval. So running off and incorporating your own company and asking your friend to serve as a nominee for you, and then renting a desk from somebody else and then sitting in front of your computer with perhaps 50,000 Hong Kong dollars in your bank account through to your MVP, that's not going to work. It used to be that if you were physically in Hong Kong as a visitor, you could not file an application for an employment visa while you were here. A few years ago, they changed all of that now. So you can file an application as a visitor while you're here. It doesn't afford you any kind of privileges as regards your continuing visitor visa status while the application, the Immigration Department consider your application. But what they do is issue you a visa label upon approval, and you take that visa label and you usually hop on the ferry to Macau and you relinquish your visitor visa status as you exit Hong Kong. You arrive in Macau, you take the visa label and put a clean page in your passport, and then you come back to Hong Kong, and then they will admit you as an employment visa holder from that point in time. And thereafter you're entitled to make your application for a Hong Kong identity card if you don't already have one. So it is possible to be here whilst your application is being considered by the Immigration Department. And then once you get approved, you can work for one particular employer. That's the employer who sponsored your visa. Any other work, paid or unpaid, outside of that envelope is unlawful, unless you've sought the Immigration Department's permission to join in a side business or take up a side employment, however that has materialised, and the Immigration Department has said yes to that side activity. But a necessary precondition, even before you start to file that application, is to have your employer who's sponsoring your current residence visa agree in writing that they have no objection to you taking up that side employment or engaging in that side business. So that's how the whole idea of part-timing and moonlighting and freelancing is dealt with from an immigration perspective. Now, what people don't understand is that under Hong Kong immigration law, the way the law is worded, if you are found in a place of work without reasonable excuse, the law automatically imputes an employer-employee relationship, and it's a strict liability offence, and you've immediately breached your conditions of stay. And it doesn't matter where you're getting paid. It doesn't matter whether you're getting paid. It all boils down to, are you engaging in activities that are employment activities in Hong Kong? And if you are, you need the permission of the Director of Immigration. Anything outside of that, you're breaking the law.